All right, today we're diving into a legal concept that sounds, well, it sounds like it shouldn't be real. It's called adverse possession. And while it feels like something from a history book, it has some very real and pretty wild implications for property owners even today.
So let's just cut straight to the chase. Can you actually, legally, claim someone else's property just by using it? And the answer, which might shock you, is yes, you can. But how you can do it is where all the fascinating details are.
So here's our roadmap for this explainer. We're going to break down what adverse possession actually is, look at the two absolute must-haves for any claim, see how the old law compares to the new, and walk through what happens when someone actually makes a claim. And then we'll get into the big question. Why does this law even exist?
Okay, so first things first, what are we really talking about here? Well, at its very core, adverse possession is kind of like a legal use it or lose it rule for land, but, with a whole lot of fine print.
Here's the official definition. It's the legal principle where a trespasser, sometimes called a squatter, who's been on a piece of land for a long, long time, can end up with a stronger legal right to it than the person who actually has the deed. I know, it sounds crazy, but it's all built on a very old legal idea.
And that idea is called limitation of actions. The best way to think about this is to imagine a giant invisible clock. The moment a trespasser starts using the land, that clock starts ticking. The law basically says a property owner can't sleep on their rights forever. They only have a certain amount of time to sue to get their land back. And if that clock runs out, well, their right to do anything about it just expires. Of course, it's not as simple as just parking yourself on a field and waiting. No way. To even have a shot at a claim, a person has to prove two very specific things to a court. Let's dig into what those are.
These are the two essential ingredients. You can't have one without the other. First, you have to show you had the intention to possess the land. And second, you have to prove you were in physical possession of it. And you have to prove both of those things for the entire time required by law.
So what does intention mean here? This is really important. It has nothing to do with having a villainous plan. The court doesn't care if you knew it wasn't your land, or even if you honestly thought it was yours. The only question is, did you treat that land like an owner would? Did you act as if it was yours and yours alone, to the exclusion of everyone else in the world, including the actual owner? And the second ingredient is that physical possession. Again, this isn't about being confrontational. As one famous judge put it, the question is simple. Has the squatter taken control of the land and started using it in a normal way? And, this is the crucial part, have they done it without the owner's permission? Because if you have permission, it's not adverse possession. It's just being a tenant.
Now, to really understand how this all works today, you need to know that there was a massive legal change back in 2003. So first, let's look at how things used to be under the old law. This system still matters for any land that's unregistered, meaning its ownership isn't on the central government database, and also for some claims that were completed before that 2003 cutoff. Under this old system, there was a magic number, 12. 12 years. That was the time limit. That was how long the ticking clock ran for an owner to sue a trespasser and get their land back. And here is the absolute kicker. After those 12 years of uninterrupted adverse possession had passed, something incredible happened automatically. The paper owner's title wasn't just in trouble, it was legally extinguished. It just vanished. Poof, gone. The law just wiped it from existence, and the squatter could become the new legal owner. It was a seriously harsh rule. But for the vast majority of land in the country today, which is what we call registered land, all of that changed with the Land Registration Act of 2002. This new law completely tore up the old rulebook and shifted the power dramatically back in favor of the registered owner. This chart really lays out the night and day difference. Under the old law, the whole system was passive. It was all about the owner's clock running out. The burden was 100% on the owner to notice what was happening and do something about it. The new law, it flips that on its head. Now the burden is on the possessor. After 10 years, they have to proactively apply to the government, and here's the game changer. That application triggers an official notice that gets sent directly to the registered owner, who then gets a full 2 years to deal with it.
So, what does this process actually look like now for most property? Let's walk through the modern-day procedure step by step. Okay, so it starts when the possessor hits that 10-year mark. They then send an application to the land registry. The registry then looks up the owner's details and sends them an official notice. At that point, the owner has a choice.
If they object, they are given a 2-year grace period to start the legal eviction process. It's only if the owner literally does nothing, just ignores the letter completely, that the possessor has a chance of getting the title.
So let's just quickly summarize the outcomes. For that rare, unregistered land, the old tough rules still apply. After 12 years, the owner's title is just gone. For registered land, under the old system, the squatter was entitled to be the new owner. But now, under the new system that covers most property, a possessor can only win if the true owner completely drops the ball and fails to object. Or in 3 very specific, very rare exceptions, like a simple boundary mistake.
Which brings us all the way back to that fundamental question. Why in the world do we even have a law like this? It just seems to reward someone for doing something wrong. But believe it or not, there is an underlying logic to it.
So, here are the key takeaways. First, the new law has swung the pendulum way back to protect landowners who've registered their property. The old automatic rule is basically dead. Second, the responsibility has shifted from the owner to the trespasser. So why keep the idea around at all? Well, the law really doesn't like to see land go to waste. It prefers to see land being used productively rather than having an owner who has effectively abandoned it and doesn't care what happens to it.
And that leaves us with the big question to think about. Is adverse possession a fair, practical rule that makes sure land gets put to good use? Or is it just an outdated, strange loophole that amounts to a kind of legalized theft? With the new law, the balance has definitely shifted in a big way. But the debate about the principle itself, that's still very much alive.